Welcome to Finance at the Jobsite, the podcast where construction finance meets the field. I'm your host, Rishi Srivastava, founder of Being Human. In each episode, I sit down with construction CFOs, controllers, owners, project managers, IT leaders, ERP consultants, and industry experts to uncover how they connect the back office with the field, choose and implement technology, manage cash flow, and drive profitable projects. Whether you are running the numbers, leading the team, or designing the systems that keep projects moving, this is your place to learn what's working, what's broken, and what's next in construction finance. Today, our guest is Ryan Heeth. Ryan, welcome.
Thanks, Rishi. Thanks for having me today.
First section is on contracts, claims, and job site reality. Walk us through a project where the contract looked clean on paper, but everything fell apart the moment construction actually started. What was the gap between what was written and what played out on site?
On a lot of projects where there's been challenges, the contracts always look good at the start. GMP is fine, price is fine, subs are fine, their prices are good, schedule's fine. But I always say, whenever construction starts, that's whenever the problems start to happen. And really, those gaps are seen through just scope gaps in the drawings, bad coordination, tons of conflicting RFIs between, the owner's different consultants and things like that. And, there's kind of this way of thinking, I think, with contractors is that, they're not responsible for the design. That's always on the owner. It doesn't matter what happens at the end. It's going to be the owner's responsibility to pay for all these things, including delays and extra costs of change orders and all this sort of stuff. And that's really kind of where the reality is a little bit different. And it's different because those types of claims really slow the project down. If there's tons of change orders, bad drawings, crazy RFIs going around, that's what really starts to take up a lot of extra time and energy from your project team. But not only that, you kind of learn that the contract is just kind of a risk allocation document as well. So if you start to have these types of claims on the project, you have to reserve your rights to those claims with proper notice, RFIs back to the owner, a paper trail on every single one of them, good schedule updates throughout the course of a project if you have a delay claim, because you're going to be looking at that later on the impacts to critical path. But just keep in mind that these claims are always extremely costly to prosecute. Not only, like I said, do they take up a lot of your project team time and effort, but it's also hard to get owners to pay for them at the end of the day. So, that's always an issue as well. But like I said, a lot of times the contracts look great up front, but once you start construction and really start trying to build the thing and you realize that there's a lot of gaps in the drawings, that's what I think really hurts projects.
You put together $1 million extra cost claims in New York City. Most people assume you just pull totals out of the accounting system. But you said that's exactly how you get yourself in trouble and even liable for exaggerating a lien. Walk us through what it actually takes to do this right.
Yeah, so I think of liens and claims as two separate things. Liens are basically, costs that you can legally include in a lien, right? Without the other side making some kind of claim that the lien is willfully exaggerated or includes a bunch of stuff that you legally can't include in a lien. And the consequences of those in court are, can be substantial depending on the state. And in New York, your lien can be struck down. You lose those rights to the lien, in your interest in the project with the lien. And you can even be, responsible for the cost of the other side for defending against such a lien. Whenever you're talking about claims, though, you're really talking about contract claims, and the contract governs those. And those are really included if it goes to litigation and a breach of contract claim. But otherwise, you're going to be making claims directly to the owner, and you can really include anything you want. So that's kind of why I think of them as two different things. Liens, you may be limited on the things that you can lien for, and with claims, you can kind of include everything that the contract allows. So that's kind of the difference there.
Very well said. On delay claims, you've described needing an independent schedule consultant to build the critical path before accounting can even price the delay. Why is the order of operations there so important, and where do most contractors get it wrong?
Yeah. So if you're talking about a delay claim, you're really talking about the net delay to the critical path or the substantial completion date. So what you're doing is you're really just trying to justify to the owner why you're entitled to either extra time in the contract or extra time and extra costs, right? And whenever you're looking at a critical path schedule and you're doing an actual analysis of it, there's going to be delays from you, the owner, subs, everything's going to be in there, right? The good, the bad, the ugly. But, if you really do have a delay claim against the owner from the contractor side, I always like bringing in a scheduling consultant up front, especially if it was going to be, a claim large enough to justify a schedule consultant, which a lot of times it is because the cost up front for a schedule consultant usually isn't that much instead of just using our in-house scheduler. And really what that did was it really added weight to our claim to the owner. It added a third party who's willing to put their name and reputation on the delay claim. And it let the owner know that we're ready to fight for this claim. We're ready to bring in somebody from the outside who's done an analysis. Here it is. Here's our case. Here's all the details, all the backup, all the, extra costs, all of our justifications in one packet for you here, owner. And what I've found is that that usually leads to quicker settlements, either, interim, change orders for extra time during the middle of the project, or whenever you're doing this, towards the end of the project. If you're able to get an agreement towards the end of the project before you do closeout, that's also preferable as well. Otherwise, the owners are just going to kick this can down the road. So you got to let the owners know that you're serious about late claims and prosecuting them.
Seriousness does matter. A lot of times people are trying to get some money without any serious work behind it. The next section here, Ryan, is where law meets finance and CFOs get surprised. You said external legal costs can't sit inside a construction lien. They have to be pursued separately as a breach of contract claim. How many CFOs and controllers do you think actually know that? And what happens when they don't?
Yeah, again, this is going to be state specific on what can be included in a lien and what cannot be included in a lien. I would assume that any CFOs that have, gone through a full litigation with a lien or breach of contract claim combined would probably know this. But like I said, it's very state specific. But every time that I've had to file a lien from the contractor side, from the GC side, or the construction management side, it's actually been pretty rare. I think sitting in the CM side, you're used to seeing these things from the subcontractors a lot more. So a CFO of a construction company probably may not see the preparation of their own lien, as much as seeing just, subcontractors hit the project. But yeah, so I would also say that some states, those extra cost claims, delay claims, unsigned change orders, all that sort of stuff, can't be included in a lien as well. So you just have to be careful with your specific state's laws and work with a local attorney before filing a lien, because you don't want to just print out all the accounting data from the project minus what's been paid and file that as your lien. I think that that's where, you know, uh, contractors really kind of step in it whenever they're going to file.
Yeah. You need to dot your I's. When does a construction problem stop being an operational problem and officially become a legal problem, even if the project team doesn't realize it yet?
I kind of frame this usually in, into those like, what does the contract say issues? Because a lot of my time as, in-house counsel in construction companies is really just being presented with a problem. And all I say is, okay, well, what does the contract say? We go and read the contract and that directs us. But really, those legal issues cross the line from operational problems to legal problems the moment somebody's rights or obligations, that time starts to run. And those can be either be like written notice requirements. If you receive a claim from a subcontractor, you might have a pass through notice to the owner, and there might be a clock for that. You could have like, change directives from owners that you need to reserve your rights to for those, extra costs and time. Like, if you have like a delay in payment from the owner, okay, how long do I have to wait till I can stop work? And then another good one that people forget is that whenever you hit substantial completion, in a lot of states, a statute of limitations starts to run on your claims as well. Time limits to file liens and claims and things like that. So those are just think of really anything that has a time to to do something, I would say that crosses over into the legal field.
Hmm. Actually, I was talking to another lawyer before, and he said when the trust breaks down between the parties, that's when it really becomes a legal problem.
I don't know, maybe. Yeah,
I think trust is there and it's still a legal problem.
possibly. I don't know.
Hmm. Okay.
I don't know. I did New York construction, so trust was never really discussed that much. So everybody was always a CYA. But another thing, one of my rules I kind of live by really was like, you know, identify issues, on a constant basis on the project. So I know that a lot of you have weekly or monthly meetings. Get those issues, like wrangle them out of the project team, make sure you're talking about them and you're identifying them. And because a lot of times in these contracts, you don't have a long time to provide those written notices of claims to the owner. So you don't want to have them basically void at the outset because you missed a notice requirement. So just keeping on top of those notices, and getting them out of your project team, your field team is good. Weekly, monthly meetings, whatever. Just wrangle them out of your project team.
You've hired and directed outside litigation counsel on major NYC claims. What do construction executives most often misunderstand about how litigation strategy actually works and what a great trial lawyer still can't do without a strong in house partner?
Yeah, construction cases, whenever they go to litigation, are extremely difficult to prosecute. And that's because they're extremely fact and technically intensive. Not only that, there's a ton of parties, there's a ton of subcontractors, material suppliers, consultants, designers. There's just tons of people involved in a construction project. And that knowledge is really sitting, kind of in your in-house team. And that's hard to get across to an outside attorney, who's going to prosecute a case. And really the outside attorneys, you know, their job isn't really to manufacture a case so much, but to manage the process of litigation, and to make the case that you're bringing to them for you, in court. You have to, as an in-house representative of the company, get the information, the relevant information to the outside counsel. You're kind of responsible for framing the case for them just because there's a lot of in-house knowledge about all these projects and they're very complicated. So, um,
I kind of feel for the trial lawyer or the judge who's evaluating these cases. It's so complicated.
yeah. Yeah, and that's another thing is, judges in the courts, they don't understand this stuff. It's always hard. And one outside attorney always told me that, whenever you're bringing a case as a contractor to court, you got to keep in mind, like judges and juries and all that sort of stuff, like they have it set in their mind that like contractors aren't trustworthy people. They're always kind of hiding the ball. Like you're kind of going to court on a back foot with just some, I guess, bad contractor reputation that you're not
Yeah.
responsible for, but that's the way it goes.
Yeah. I was watching this show, Jury Duty, and one of the lady in the jurors, she was always sleeping.
Yeah. 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 Good luck trying to explain a delay claim to a jury like that. It's good luck.
The next section's hidden profit centers in cost plus GMP. You gave a great example on our prep call, paying a PM $100 per hour, but billing them at $150 per hour through agreed labor rates in the quals section. Unpack that for our audience. How does a contractor quietly turn general conditions into a profit center?
Yeah, and we're talking about framing this in the context of a cost plus with GMP type of project, right? So I loved the business people that really use the quals. And when I say quals, it's the qual exhibit to the GMP, which includes clarifications, exclusions, all that sort of stuff. We always just kind of packed them into one exhibit. You can get really creative in there, right? The AIA will say one thing, but you can change all those deal terms in a call sheet because everything in these contracts is a negotiation, right? And what we would do is we just put in the very top of the exhibit, the price in GMP is based on and subject to the following qualifications, clarifications, and exclusions, right? And what we would do is start to use like agreed upon rates for certain things. And I use labor rates as an example because it was just kind of an easy one. And it's also a huge general conditions line item in most projects, right? Or the biggest. And so if you agreed to that, all right, we're going to bill this PM out at $150 an hour, but you're really fully burdened at $100 an hour, you're going to make that spread. So you kind of have a little bit of hidden profit in the labor you're charging to the project under your GCs. Now, obviously, you're still limited by the total GMP. But remember, those labor hours and labor rates and everything, they tie into the schedule, the GMP schedule, and the staffing chart, which drives that GMP. And if you do that, you just kind of pick up extra margin here and there.
Yeah. And this lawyer stuff's so hard.
Yeah, I was trying to think what else you can also do. I mean, you can do it with other things like insurance and maybe, I don't know, maybe like some equipment rental things like that. You can really kind of look through what you have in your GCs and what you can agree to just say, okay, we're going to charge this rate for this thing and see if you can make a spread in there somehow. So, but yeah.
Beyond labor rates, what are the other levers in cost plus GMP that move contractor margin? Insurance markup, shared savings clauses, contingency, fee base.
Yeah. And again, we would use the qual exhibits for a lot of these things as well. But, if you can find a way, and a lot of companies do, to charge a margin on insurance, that's always a great profit center. And we can talk about a little bit more, but programs like SubGuard and CCIP, your commercial general liability and bonds and stuff like that, you can always, charge a margin for. And again, you can just charge a rate for it, which I'm sure a lot of people listening to this call already do. Another thing was contractor contingency. Well, obviously the biggest thing on the legal side is who controls it. Like the contractor always wants to control it. You don't want the owner with his finger on the button and a big gatekeeper of the contingency. But to use it as a profit center, obviously, is just to use as a shared savings clause. And you can have the contingency in the shared savings, and you can just have anything that comes under the GMP as shared savings as well. So that's kind of another way to pick up some extra money in a GMP. Sometimes I've had owners try to lock in a fee. Is it like a fixed fee and not a percentage fee? So if anybody out there that has owners just trying to set like a total lump sum fee for the project that's not tied to a percentage of the cost, obviously you want it tied to a percentage of the cost. So the fee goes up as the project costs go up. This one was a little bit hard to get, but change order markups, I always tried to get it. I always tried to get a little bit of extra percentage points in the GCs on change order markups. Let's say GCs on your GMP, schedule values comes out to, I don't know, 10 or 13%. But in your change order markups, you can set whatever you want. You can say, okay, well, I want 15% GCs on my change order markups. So you can have a little bit of wiggle room there to, kind of blunt the impact of having to manage change orders by just getting a little bit more extra percentage points on your GC's markup in your change orders. Also, a lesson learned on change order markups: make sure in the contract you include all the things that you need markups on the change orders for, especially things like insurance markups, and agree to the rates. Have like a whole, all right, we're going to agree to these 3, 4, 5% markups on change orders to cover certain things. I've seen a lot of contracts that'll say, okay, fee and GCs will give you a markup of 15%. And it doesn't say anything about insurance. That was always a tough one to come back to the owner for and ask for more money. And then I always liked incentives for hitting milestone dates. I always thought that they were great. Sometimes we had those directly go to the project management staff, and it paid their bonuses, and it was great for retention. And the project management staff really loved them. They were out there working hard, showing up early, getting the projects done, and they were getting rewarded for it. But you can also split that up, give some of that milestone bonus to the project team, and then maybe keep some for the company as well. But I always love milestone bonuses, especially if we were like super certain we were going to hit them, top out. Different milestones within the project. You can be really creative with them as well, with all these things.
People love them. You've negotiated against owners pushing for things like a $1 million cumulative threshold before change order markups apply. From the contractor's seat, how do you defend that markup? From the owner's seat, how do you actually agree with the contractor's argument?
Yeah, so I think dealing with a couple issues there. One is defending again, for the markups, right? You need your change order markups, you need additional general conditions and fee and insurance and all that sort of stuff that are going to directly relate to managing those change orders and change order process. And the other one I saw a lot in New York was that owners wanted a threshold of cumulative change orders before they would allow markups to start to be charged to them. And, I kind of get it from the owner side. Like his argument is always, oh, you're already on site. You already have it staffed. All projects have change orders. It's just part of general conditions that you're charging me for this project. But on the contractor side, I would always say, well, how many change orders are you going to have on this project? Is it going to be 5? Is it going to be 500? Like, I don't know. How would I agree to a threshold when I don't even know how many or what kind of change orders or what it's going to take to manage them? I can't see into the future. I can't see into the changes that are going to come in the drawings. So it always was a good back and forth.
Yeah. The next section is the switch to the owner's seat. You are now running real estate development in the Cayman Islands with a $100 million project on deck. What's something you watch like a hawk as an owner that you didn't fully appreciate when you were on the contractor side?
Yeah, I mean, from this side, I'm mostly concerned about the project finances, right? And the thing that I really have watched the most is the schedule of values. And I really don't want them being front loaded by the contractor. And for all the reasons you can think of, I have to pay interest on those amounts. The work isn't being performed, but the money's already out the door. So I'm at risk if the contractor or the sub walks and they've already been paid for it. And then I'm concerned about the contractor having enough money to finish the project at the end of the day. We're on a small island. It's not like I can just pick up the phone and call somebody else to come out there and pick it right back up. We could do some serious damage if I don't have enough money at the end of the day to finish the project and the contractor walks in the middle of it. Just watching the schedule values and trying to prevent a bunch of front loading to it is really what I'm I'm watching right now.
Yeah, yeah. As your seat changes, your concerns change too.
Hmm.
You said your current contractor wants to do a lump sum design build, closed book project, and it quote unquote drives you nuts. Why is that structure so dangerous for an owner on a big build? And what do you give up versus a cost plus GMP?
Yeah, I don't know, if I would call it quite dangerous because I'm also passing off a lot of the risk to the contractor, right? I'm passing off pretty much all the design risks to the contractor, which is the owner's biggest risk on something like a cost plus or the GMP. So I'm actually getting a lot of risk off of my plate. But what I'm really losing is all of that transparency like I would have in a cost plus with a GMP type of contract because it's with a lump sum, it's closed book. I don't see through. I don't see the trades. It's hard to, figure out who's being paid what. I don't get to see all that information, and I also don't get to be involved in the bid outs, right? With the cost plus of GP, the owners are involved, in basically the buyout of the project with the contractors, and I have limited rights to audit the contractor's costs, right? And even if I do, it doesn't really matter anyways, because he's going to make the spread on all the trades. So just for me, on any project, I love just the transparency. I like knowing who the subs are on site, where the materials are being bought from, and with a lump sum, you might not get all that. But like I said, with the design build, you know, I do offload, that design risk onto the contractor, but I also lose design control a lot, right? Because I'm telling the contractor to build, in this case, a commercial project, but he can go and pick almost whatever materials he wants. And, what it looks like on the drawings now and what he picks for materials at the end of the day, might not quite look exactly like I would want it. But in reality, we're building a white box commercial space. So this type of contract's a little bit more fitting because, as long as the exterior looks nice, the inside's a white box, the tenants will do their own fit outs and I don't really care less what the inside looks like, you know, tile wall finishes, painting, none of that's for me. So for this project, it fits a little bit nicer, but most every project, I wouldn't go with a design build or a lump sum really.
So, what are the factors that uh, sway you one way or another?
Between the different contract types,
Yeah.
At the very outset, I would say it's really like design control, really, right? Because like if I'm going to do we're doing another project that's residential, I got to have design control over all the interior finishes and all that sort of stuff because I have a product to sell, to a residential buyer at the end of the day, and I got to make sure it's beautiful and correct, and it's something that someone's going to want to buy and live in. Like this commercial project, like I said, it's a white box. Right? The people who are going to be leasing the spaces or owning the spaces are going to fit them out themselves. So that's probably, the design control is really the differentiating factor in whether I want that or not.
Building on an island isn't building in New York. What's surprised you most about how a Cayman project actually gets stood up? Design, subs, materials, permitting, timelines.
Yeah. Well, New York, it, is an island, but it has in New York, you just have so much accessibility to subcontractors, materials, everything is within a 20-mile radius, right? Being in Cayman, you're on an island, a real island in the middle of the ocean, and everything comes by boat. So what that means is logistics is super important, and that's going to affect cost, schedule risk, all sorts of things. For example, with the Iran conflict, and the increase in oil prices, now all my shipping costs are a lot more, and everything is coming by boat. So that has become an issue. I will say, Cayman's not quite like some of the other Caribbean islands. It's like a pretty well-oiled machine when it comes to construction. There's a lot of real estate projects going on there. There's a lot that's happened in the past. And that means that the subcontractor base and the supplier base there has really been built out over the years by some big developers there. And so that's been really kind of a refreshing thing because when I first showed up, I I had the same question. Who's doing the work on the island of, 80,000 people and how are you getting all this stuff to the island? But it's actually not that big of a deal down there just because the subs are so well built out down there. I will say that building in Cayman is like building in a small town. It's an island of like 80,000 people. Everybody knows each other. All the subs, all the contractors are super tight, probably related to each other. It's like a real small town. So you don't want to be stepping on any toes down there because, your reputation will get around the island real quick.
I also live in a small town and I can totally relate to what you're saying. It's small town, everybody knows everybody.
Hmm.
The last section here and is financing, insurance, and career lessons. You are financing a $20 million Cayman project through private credit, investment funds, PE money, wealthy individuals, because the islands don't have US style construction banking. Walk our audience through how that actually works versus a traditional bank deal in the States.
Yeah, I'm not really the complete finance person in our group, but I will say that doing something out of private credit allows you a lot more flexibility. Institutional banks are just, basically box checkers. As long as you meet, their metrics, everything's good to go. So they're very process oriented, but private credit's not quite the same. So you can be a lot more flexibility with the terms of your loan. You can which can fit your project better. So you're not just trying to fit the project in the bank's box. The private credit guys are trying to fit their loan into your project and what your project needs. So that's really the biggest help there. But if you have a loan that's, syndicated through private credit, just got to remember on the other side, you could have, one money person or you could have 10 and they all have their opinions on your project, on the loan agreements, on what you should and shouldn't be doing as an owner or what the contractor should and shouldn't be doing in their construction contracts. So you could have a lot more parties with their hand in the financing discussion whenever you go the private credit route.
It's most of the time it's bankers who are deciding these projects.
Hmm.
CCIPs and OCIPs sound boring on the surface, but you've seen them quietly become major profit centers on the right project. Where is the bar? What project size? What kind of contractor or owner before this is even worth considering?
Yeah, it's a great question, and I can really only speak to it from the contractor side. We don't run an OSIP. down in the Caymans. But from the contractor side, if you're out there and you don't run a CCIP program, it could be a great profit center. And there's really not like a one size project that fits in them, because you could literally fit all of your projects into the CCIP and it'll be covered in the CCIP. The CCIP really matters about a total volume of what you're running through the program. And, kind of a lesson there is that, when you're working with the carrier, you need to kind of make sure that you're agreeing to run a certain amount of volume through the CCIP that you can get through the CCIP, or there could be some penalties on the other side if you don't run enough volume through the term of the CCIP program. So it's really just kind of an aggregate project size that run through these CCIPs. But I would say that if you don't run a CCIP program, really understand how to sell it to the owners and, the benefits of them, and the biggest benefits of them is that you're really wrapping up all the subs into one insurance policy. So you don't have 20 subs on a project with all different general liabilities and excess coverages from all these different carriers with all these different expiration dates and renewal dates that you have to track and all that stuff, kind of takes a lot of that away. And whenever you run a CCIP program, if you run it through like a good broker, they'll administer it as well and all the compliance for the carriers. So, and then whenever you run a CCIP program, and the way that you make a profit on it is really you're just kind of sharing the profit with the carrier, is you're agreeing to share some of the profit of the policy with the carrier.
The last question here, Ryan, is looking back across purchasing agent, in-house counsel for a NYC construction manager, and now developer side in the Caribbean. What's the one lesson you'd give a CFO or controller listening today that they won't pick up anywhere else? And if you want to make the pitch for your insurance broker, this is the spot. That intro is earned.
Yeah, thanks. Yeah, I appreciate that. I'll kind of give you a funny one that's come up in the past for me a lot. Whenever your project teams are out there agreeing to and signing change orders, be careful that the owner is not slapping a cover sheet on top of that change order, and with the signature pages and everything for it, that includes some extra language, like signing this change order. This is one that I've had a lot. Signing this change order, you waive all your rights to any delay claims or extra cost claims related to the work in this change order. And your project teams could be out there thinking that like, okay, we got a change order signed, all good, throw it in the accounting system, we increase the GMP value, and we're off to the races. But what they could have done is waived a lot of rights to future claims, especially delay claims related to that change order. And those could be claims really that you don't even know exist at that time that you're signing them. So, just this is like a lawyer speaking, just have your teams be super careful what they're signing out there, because it could have a serious impact on the project and the project finances at the end of the day.
Yeah. When you're excited, oh, we got the change order signed, don't waive all your rights. Ryan, I had a great conversation with you. Thank you for your time today.
Thank you, Rishi. Thanks for having me.
Thanks for listening to Finance at the Job Site. If you found today's conversation valuable, share it with a teammate and subscribe so you don't miss the next episode. You can listen on Apple Podcasts, Spotify, or Audible, or watch on YouTube. Just search Finance at the Job Site. Until next time, here's to building smarter, faster, and more profitable projects.